Trial captivating a nation.
Jennifer McCabe spent longer than anticipated on the stand, sharing what she says Karen Reed said as first responders were trying to save John O'Keefe.
Your client said, I hit him, I hit him, I hit him.
She repeated, I hit him, I hit him.
She's testifying to whether or not it was a direct statement, I hit him, versus a question, did I hit him?
It's always inconsistent. Don't take anyone's word for it.
And no more nonsense. Let's just try this case.
NBC 10 News has the latest on the retrial of Karen Reed.
And this is our daily Karen Reed debrief, just after 5 o'clock. I'm Brian Crandall in today, and we're waiting for Katie Benoit to join us. She was outside the courtroom as Karen Reed left just a short time ago. The development late today is the defense. Karen Reed's attorneys rest their case. We're going to get closing arguments scheduled on Friday in this much anticipated murder retrial of Karen Reed, accused of hitting and killing her boyfriend, Boston police officer John O'Keefe, in a snowstorm a few years ago outside a friend's home in Canton. Of course, she claims that she was framed. All right, we're going to be joined by Austin Dana, who's with the Ketchus Law Group, our attorney and legal analyst who's been, watching this trial all along and what's happening. Austin, what do you get from today with the defense resting? The prosecution didn't call any rebuttal witnesses. Anything catch you by surprise there? Anything stunning about them being done at this point?
I think so, Brian. I think we anticipated that the prosecution was going to call rebuttal witnesses. They had been alluding to the fact that they intended to throughout the entire defense case. There was an issue about whether or not they had elicited testimony involving DNA evidence and the lack of DNA evidence that pointed to no dog DNA on Mr. O'Keefe's sweatshirt. And when the prosecutor elicited that evidence, he said, well, we intend to call a rebuttal witness who's going to prove that there was no dog DNA on Mr. O'Keefe's sweatshirt. And now the defense rests, and we see the prosecution say, never mind, we're not calling anyone. We're ready to close. So that's a bit of a surprise to me.
At what point, right, you got the battle of experts back and forth, right? The prosecution has their experts on crashes and autopsy results, and then the defense does the same. At what point, as an attorney, does all that maybe with the jury start to wash out and they're maybe done with that kind of stuff? Because you could probably go back and forth forever.
You certainly can. You can have an expert for anything, and you can have another expert who's going to come in and say something that's opposite to what the original expert said. And does it wash out? Sometimes it can, but sometimes it can also become a battle of the experts. And which one do they believe? Which one holds more credibility with the jury? Which one presents better? And which one has opinions that are actually based in science? And a lot of what we've seen are experiments by the Commonwealth's witnesses and now experiments by the defense witnesses. So the jury's left to weigh both of those. Who's more credible here? Who's actually doing experiments that hold weight and prove something? So those are the questions that the jury's going to be weighing when they get back into the deliberation.
And do you think the jurors, based on what you saw, would lean one way or another?
From what I've seen, it appears that the ARCA witnesses on behalf of the defense are doing more scientific experiments that are based in actual science. And they're poking holes in what the Commonwealth has presented. From the Commonwealth, we're seeing things like putting paint on your arm and allowing a SUV to hit your arm to show that the arm could have been hit by that SUV. Conversely, with the defense witnesses, we have crash test dummies. We have the SUV moving at different speeds. There are a lot more experiments that are based in actual science on the defense side from what I've seen so far.
And do you think it helps them that they went, they get the last word, so to speak, when it comes to the experts?
Of course it does. I think that anytime that you're looking at a trial, there's this concept of primacy and recency, and you want to have the first word so that you're fresh in their mind and everything that the jury sees is through the lens of what you've presented. But you also want to have the last word, because that's the last thing they hear when they go back to deliberate. That's fresh in their mind. That's what they're thinking about when they sit down and start discussing the case.
So just walk me through what happens now, because closing arguments are scheduled for Friday, but there's some stuff happening before that. And again, it's behind the scenes stuff in terms of, jury instructions and stuff like that. So what happens behind the scenes? There's obviously been a lot of back and forth and disagreement between the sides on this and what the jury is going to hear.
So the first thing that is probably going to happen, if it has not already been discussed, is a motion for a directed verdict where the defense says the prosecution hasn't proven their case. Judge, there's not enough evidence for any jury anywhere to find Miss Reed guilty. Therefore, you need to step in and you need to say that she's not guilty before it even goes to the jury. Very rare that a judge grants that motion, but it's, as a matter of practice, it's one that happens. The next thing that they're going to be doing is called a charge conference. So at 10 o'clock tomorrow, all the attorneys will come in and they'll sit with the judge and they'll go over what instructions the jury's going to hear in this case. What's the law that the judge is going to tell the jury they need to consider? And there's going to be back and forth. Each side wants different instructions given by the court, and each side wants those instructions worded a different way. So there's a lot of background negotiation and debate that goes into the instructions that the judge will eventually read to the jury. So that's the main thing that's going to happen tomorrow. Then they'll look at exhibits, figure out what's going to go to the jury, what doesn't go to the jury, make sure those are all squared away. And we'll have closing arguments on Friday after the charge conference is completed tomorrow.
Right. And so, as an attorney, this is kind of the big moment, right? This is, as you said, the final chance to make your case now in the closing arguments based on all the evidence that's been presented and the testimony. Do you want to walk us through potentially what your strategy would be on each side? What briefly, kind of what you would focus on and what you think are the main points that the jury needs to hear?
I think from the prosecution, you're going to see a lot of these videotapes that they've been playing throughout the trial, statements that they find incriminating that Ms. Reed made to the media after the first trial. And they're going to be playing those probably throughout their closing statement. They're going to be focusing on the cell phone data from Mr. O'Keefe's phone, the data from the Lexus SUV. And this is their chance to really tie a bow on what they believe to be the forensic evidence in this case that proves that she backed her SUV up, and that coincides with the time that Mr. O'Keefe's phone stopped moving around and the temperature started dropping. Conversely, on the defense side, they're going to say, no, none of that makes any sense. And what you're hearing is a lot of things from the prosecution that they're trying to tie together, but none of it really fits. So let's break it down and peel back the onion a little bit and see why this does not make sense. And it doesn't make sense because of the experts that we've called. And again, the burden's not on us. It's on the Commonwealth to prove this case beyond a reasonable doubt. We don't have to prove anything, but we have proven that their case makes no sense, and there's an alternative as to how this could have happened. So I think those are the gists of both closings that you're going to hear from one side and then the other.
And do you think, going back to what you were talking about at the beginning about the prosecution not calling a rebuttal witness on the dog bite DNA or lack thereof dog bite DNA, as a defense attorney, do you bring that up and point that out that, hey, listen, they never offered an alternative to why this couldn't happen? The dog bite.
Right. That's a tricky one, because do you bring more attention to the fact that he brought that up and there was no evidence of it? I think you probably do, because it tends to show that Mr. Brennan is getting up and he's arguing things that aren't in evidence. I think there were two things that you can point to. One being the fact that he said there's no dog bite DNA on this sweatshirt with no evidence of that whatsoever. But the other one being that he pulled the sweatshirt out knowing full well that the holes in the back of the sweatshirt were cut by a crime technician and were not caused by being dragged across the asphalt, and suggested to the jury that the holes in the back of Mr. O'Keefe's sweatshirt came from him falling and being dragged across the asphalt, with no evidence of that, and in fact evidence contrary to that. So it really dings him on his credibility to that jury. And I think I probably would bring both of those things up in my close.
Right. And I know that was, earlier this week, but how big of a point do you think that is, for the prosecutor to misspeak, whether it was intentional or not like that on a piece of evidence and how it got damaged?
I think it's a big deal. I think it's a very big deal. I think it's a big deal, number one, for the jury and how they view this prosecutor after he's made an argument to them through his cross-examination, and then the judge has said there's no evidence of that. In fact, that's not where these holes come from. When you lose credibility like that, I think it's a big problem for you in front of a jury. And I think it's a problem too when you are making representations as an officer of the court if you know them to be untrue. I know Mr. Brennan said it was just a mistake, an honest mistake, but it's a pretty big one.
And Austin, just before we let you go, now that the testimony is done, we talked about who did testify. Just for a second, who didn't testify? No, I want to start with Michael Proctor, because that was like the big thing in the first trial with those really damning text messages that he got caught sending about Karen Reed. He doesn't get called in this one. The prosecution doesn't call him because I'm guessing they don't want that on their hands. But I guess, what do you think of the defense not calling him either and making, one of the state's lead investigators look bad?
So the defense, I think, was able to get most of the evidence in that they wanted to about Mr.
Right,
Proctor.
they had the texts, yeah.
They got the texts in. They got the text in through his friend, who was also on the text train. Guy got dragged in and had to read text messages just because he's on a text train. But those texts come in. The jury sees them. They know what the investigation was. And now they're left with this kind of boogeyman figure of who is this Proctor guy? And it lets them imagine who the lead investigator was here. So I think by not calling them, they keep the jury wondering who he is. They get the bad stuff out through other people, and they don't give him a chance to take the stand and try to rehabilitate himself in any way. All
right. And again, just quickly, I think Karen Reed doesn't take the stand in her own defense. They kind of left that hanging out there for a while, but is that really a surprise? And then, of course, the prosecution, I assume, didn't think she was going to testify. And that's why they're playing all the interviews she'd done. They try to catch her in different statements. Yeah, generally, as a general proposition in a criminal case, you don't put your client up there unless you really need them to prove something. And there's no other way that you could prove it because you expose them to cross-examination at that point. So not a huge surprise that she didn't take the stand. They probably feel like those video clips, while the prosecution thinks they're compelling, really weren't that compelling when you look at the big picture of everything. And there's no need for her to get up there, expose her to cross-examination if they have a good case going into closing arguments. So not a huge surprise that she's decided that she doesn't need to take the stand in this one. All right, Austin, I want to thank you again for joining us. Austin Dana from the Catches Law Group, who's been providing his expert analysis throughout for us. And we'll see what happens coming up with the closings on Friday. And then, of course, jury deliberations. Thanks, Austin. And Katie Benoit is now with us from outside the courthouse in Dedham, as she is every day. And Katie, Karen Reed left the courthouse just a short time ago. We'll work backwards. What happened there?
Sure. So Karen was pretty talkative today. Obviously a big day. The defense wrapping up their case. And she says that she's ready for closing arguments. Last year with the mistrial, she also spoke about looking at the charge sheet, also looking at the jury instructions when those go out to the jury, probably on Friday after those closing arguments. So that's something that she spoke about her and her attorneys will really be looking at on Friday.
Did you get any sense from what she said about how she feels? And of course, she didn't testify in the case. Were there any questions about that? And again, not really surprised when the defendant doesn't testify. But as I was talking to Austin about, they kind of left that hanging out there. That maybe she will.
Yeah, she seems ready for the next step in this case. She said that the defense case was a little bit longer this time around. It was a week and a half. Last time it was only a few days. And she said they put a few more witnesses on the stand. And she thinks her case is better this time around.
And what was Austin was talking about, how the prosecution is not now ending up calling any rebuttal witnesses. And he pointed out, especially on, they kind of put it out there that there was no dog DNA on John O'Keefe's arm, but now they're not calling anybody to show that. Was that a bit of a surprise that now this is it?
Definitely a surprising move. We were expecting at least 3 rebuttal witnesses to be called. They filed the paperwork for that. There was some back and forth. Obviously, the defense was objecting. But yeah, definitely a surprise. It sounded like up until yesterday, there was plans for a rebuttal case. And now that that's not happening, this case seems like it's getting streamlined along a little bit quicker. Last time when the mistrial happened, it seemed that everything moved so quickly as well. Things were just happening one thing after another. So this case, you kind of really can't tell when things are going to happen. It's always a surprise. Something will happen and you're like, I didn't see that coming. So definitely a surprise that there's going to be no rebuttal case.
And Katie, I asked you about Karen Reed outside of court. We have some of that right now, so we'll go ahead and play that and take a listen.
Did you guys rest?
How do you think Dr. Rentschler did today?
He was terrific, as always. Honest and stood by his analysis and answered truthfully.
How do you feel like your case closed?
I'm ready. Yeah, I'm ready.
Why 90 minutes? What can we expect to hear?
All the facts, all the truth, everything that went wrong with their case.
What do you make of the prosecution not calling any rebuttal witnesses?
They don't have any analysis and they don't have any facts to present through Dr. Welcher, so they're done.
Karen,
what do you want the
Karen,
jury
you had
to
said
know?
before you have butterflies at this stage. Are you feeling those?
Yeah, of course.
Do you think your case is stronger this time?
I thought it was strong last year. It's stronger. Yes, we just called more witnesses and laid out more of the case.
How do you feel about the jury?
I feel good about the jury. Yeah, we selected them. I was there. I took part in it, and we chose fair and truthful, civic-minded citizens of Norfolk County.
What do you want the jurors to know as they go get their instructions?
I just hope they were listening. That's all I can ask for. They were in the same room I was for the last, I don't know how many days that was, 33 days.
31.
Given what we saw play out in the last trial regarding the verdict forms and what we now know that the jury found unanimously came to a conclusion, what are your concerns going into it this time around?
Obviously, after what happened in the first trial and what we heard from the jurors that came forward, we just have to have an even keener eye on the verdict form and the jury instructions.
Okay, guys,
Talk about the
here we go.
Switch to the police investigation.
All right, and this Karen Reed once again leaving the courthouse in Dedham after the end of testimony. Katie, what was your sense? We don't see the jury per rules on TV. What was your sense as things were wrapping up? And again, the defense got the last expert witnesses in there. Now we'll hear closing arguments on Friday. But any sense of what the jury was looking at or the mood was in there today?
Sure. So the jury overall during this case, most of them have been pretty attentive. Some take notes. There's one or two who I never really saw notes. Unfortunately, this week we were not selected by the randomizer to be in the courtroom. So I was in the media overflow room. But next week we will be in the courtroom when deliberations start. If there's a verdict on Monday, Tuesday, Wednesday, we will be there. So we'll have eyes on the jury then. But also, these jurors listened to a lot of testimony. It's been weeks, 8 weeks that this has been going on for. So definitely a long time. There was a sense earlier this week that the judge said these jurors were getting frustrated with the amount of sidebars and the amount of kind of conversations with the lawyers happening, the jury being sent out and then coming back in. So there was a little bit of frustration the judge had sensed, but overall, they seem to be paying attention while I was in there.
Yeah, and right. If you're not watching the live stream, and we show the highlights on TV at night. If you're not watching the live stream, there is a lot of back and forth. The jury gets sent out, the jury comes back in while the lawyers are arguing stuff. So behind the scenes, my guess is it can be pretty frustrating for them. All right, Katie, we'll let you go. We'll see you on TV at 6:00. And again, the end of testimony in Karen Reed's murder retrial today. They'll talk about the instructions for the jury tomorrow. Closing arguments now set for Friday. All right, have a great rest of the evening, everyone. And thanks for joining us on our Karen Reed Daily Debrief.
The trial captivating a nation.
Talking about when those taillight pieces were found.
Video was played for the jury of Karen Reed's SUV in a secure area at the Canton Police Department. The car arrived a little before the first piece of broken taillight was found at the scene. The defense alleges evidence might have been planted. Proctor was seen on camera near Reed's broken taillight.
This unequivocally shows that Michael Proctor walked toward the right rear area of that SUV.
NBC 10 News has the latest on the retrial of Karen Reed.